Hello everyone, this is Rajiv Askhana for immigration.com, the law offices of Rajiv Askhana PC. This is our bi-weekly community conference call. Everybody is welcome to join in, ask questions. Uh, I want to quickly comment that today I may not be able to take new questions because we have enough questions posted already. And I think Monica did not close the thread in time. So we kind of went about 7 or 8 questions more than I normally take. I take about 20 questions, and that pretty much fills up about 40 minutes. So we'll try, but I don't think I'm going to have time for new questions. Let's get started on the questions right away. Page 123 says, I am on H1, I-140 approved, 3-year extension is here, used AC-21, okay, maxed out 6 years. If I were to switch jobs, and if my current employer were to revoke my green card application, would I be eligible to switch jobs and utilize the 3 years? No, no, because if the I-140 is revoked, you will not be able to get more H1 transfers based upon the revoked I-140. I don't think so. Would I be out of status if I were to switch jobs now? Since I have, oh, by the way, I want to add, once you have transferred over and then the employer revokes it, for example, let's say you stayed with the old employer, the new employer got the H1 approved, then you transferred over, and then the old employer revoked the green card I-140, no problem. Whatever they have already given you, government is not going to take away. So the safe thing is to get your extension and transfer and then change over. Don't do it before. Would I be out of status if I were to switch jobs now since I have maxed out my 6 years? And I've already answered that question. Of course, if you don't get an extension, you'll be out of status. You don't have a 485 pending. If you had a 485 pending, you would be okay. What are the options if I wanted to utilize the 3-year extension with a new employer? And what I just told you, don't change employers until the transfer is complete. That way, the old employer will not revoke your I-140. Eldo says, yesterday I got an NOIR on my approved H-1B from April 2013 to April 2016 based upon my approved I-140. The NOIR says site inspector visited the office at client site, but you are working from your home site, which is not a part of the LCA, and it's quite a distance from the office location of the client. So unfortunately, you are required to actually have an LCA for the home location as well. And if you don't, government can yank the H1. Okay. So there are reasons why you're working remotely, and you have a child and your wife is a PhD student. And if you don't respond by July 12th, they'll revoke your H1B. What are the safe options? Same client, same project, everything is just the same, remotely logging in. Can I change employer if the approved H1B is on NOI response review stage? And the answer is the response review is not going to take that long. Okay, so even if you change employers, if the NOIR leads to a revocation, then you'll have to step outside USA and come back on a new H1B visa with a new H1B approval for a new employer or the same employer. Okay, you can do it with the same employer also. 2, what will happen to my status if the H1B is revoked and another H1B is in process? If this H1B is revoked and they will give you another H1B, let's assume that everything else is okay. When they give you the new H1B, they'll ask you to go get your visa stamping from your home country. Okay. So, but we have seen cases where if the revocation has not yet been finalized, USCIS has approved a transfer over, but that's not consistent. Okay. What is the worst case scenario? If I have to go to home country, is there any impact on my case? No, it shouldn't be. And this is not unlawful presence. Unlawful presence only occurs once your I-94 expires or once your case is revoked by the government. And even then, if it's less than 180 days, it's not going to hurt you. Visa stamping itself is quite difficult. Having been in a situation where you're working from home should not make it any worse. Okay. How soon should I leave the country? Before 180 days, as soon as possible is a good idea. PNPK 2014. I have been on a valid green card sponsored by spouse, a US citizen, for the past 3 years, now considering applying for citizenship. My Indian passport expires in 60 days and it says final. That means I'll have to apply for a new Indian passport. I am not aware of any validity requirement when applying for US citizenship. Is there a passport from your home country required? I don't think so, but you can double check with USCIS. Okay. Um, I I would definitely double check with USCIS, call their customer service, or go through your congressman's office. In the meantime, start your N400 as quickly as you can. The name on my social security card is my maiden name. Indian passport is married name. Will this be an issue for US citizenship? No, it should not be. Next question, Raghu2082. I am in EB2 category India with a priority date of December 2009. 485 pending for more than 2 years. What if I start an MBA? Okay. And the employer is okay giving me a leave of absence. Are there any risks taking this approach? Well, there are a couple of problems. When you have a green card going 485 pending, sometimes change of status to F1 can be refused by the government. But I have seen that for MBAs, government seems to be a little bit more lenient than they are for other cases. So you can try, and remember, you can go to school without getting on F1. You can actually go on F485. Okay, so that is certainly a possibility. Um, the more tricky issue is I have a green card application going and I change over and go to school. What does that do to my green card application? The government can question whether you have the intention to join the employer back and whether even after getting the MBA you take the same job. But all in all, I have not seen these questions being asked. Nevertheless, you should be prepared for questions that include how come the employer, if they have a permanent job for you, can let you go and wait for you for 2 years to come back and join? And two, if you have a higher degree, why would you join the same job, the green card job? Okay. Next question is SG22. Current H-1B visa stamp and passport is good till Jan 2016, based upon approved I-140. Wife got I-94 at the port of entry expiring March 2015 because of the passport issue. Since the I-94 for her is only good till March 2015, what is the best way to get it extended? You can try going to CBP. Try going to the same airport or any airport. CBP has a list of their officers and try to see if they can issue her an I-94. I don't think they will. Okay. You may want to use form I-539 to extend her H-4 to coextensive with your H-1B, which appears to be Jan 2016. So I-539 would be a good way to go. She cannot stay beyond March 2015 until I-94 is extended. If you apply for her extension using form I-539 before March 2015, then she can continue to stay until the case is decided. Okay. Any news on the EAD for H-4 candidates? Well, as you know already, till July, it is still open for public comments. After public comments are closed, they'll take maybe typically 30 days or so to decide on the comments. And then finally, after that, they will decide on the regulations. So I don't know how far it's going to be, how quickly it's going to be. Maybe September, October 9th timeframe, but it's difficult to say. Next question is from Neha German. She was born in Germany, but she's a US citizen. So if I apply for green card, will I be charged to Germany? If you are an employment based or yeah, you will be charged to Germany. It's the country of birth. not the country of citizenship that matters. And if your husband were to apply through his employment, he can use Germany as the country of chargeability under the principles of cross chargeability. Does applying for diversity visa have an adverse impact on green card application filed by an H-1B worker? No, no, it does not. F1 Chinna is Krishna, who wants to know, my H-1B petition got denied recently and my employer would be filing for MTR. My current STEM OPT expires on July 15th. Can I continue to work while the MTR is pending? I don't think so. I don't think so. I don't believe that option is available. Also, while the MTR is still pending, my client is in the process of changing the vendor. The new and the old vendor are in favor of providing me any documents that I may need for H1. How do I support the MTR? You can't do it with a vendor change because you are a quota H1. You can only do an MTR with the same employer. And if the employer was the vendor, you're stuck with them. Ramesh ASW is on the 7th year of his L1A. So he wants to know, if I change to H1 for a cap exempt category, like a non-profit research organization or an educational institute, does the cap still apply? And the answer is yes. Just because the employer is quota exempt doesn't mean you are 6-year cap exempt. So if you've got your 6 years of H1B or 7 years of L1 already gone, you cannot take H1B, even for a cap exempt employer. You have to leave USA for 1 year. Cap exempt employers get you exempt from the quota. They don't get you exempt from the 6-year limit on your H1. Mr. Sekhar has corresponded with me during the last conference call for his current H1B EB2 situation. So his attorney says that there is some issue, can't file perm because there's a 30-day cooling off period after the 30 days of web-based ad placement. Well, here's what bothers me. This is a fairly basic requirement. That 30-day cooling off period, it's only for one particular advertising, which is called job order. It's not for web-based advertising, it's for job orders. And that cooling off period is well known by any lawyer who does firm-based employment cases in their practice. So did they make a mistake in calculation, or did they not know about the law? If they did not know about the law, that really would concern me, because lack of experience is obvious from that lack of knowledge, and that's not a good sign. Perm is complicated enough, even for seasoned practitioners. I think it'd be a good idea if the employer also consulted with or got a more experienced attorney involved. And there is no alternative to it. If he's talking about, I think he's talking about the job order. Job order requires that 60 days, 30-day posting, 30-day cooling off. Okay, can't do anything about it. Manish wants to know, thank you. Okay, I got my H1B approved with profit organization and lottery this year. Now the end client is offering a full-time job. End client is DMV, which is a government organization. Can I transfer my current H1 to non-profit? DMV is not non-profit. I don't believe government organizations are exempt from the quota. They're just like everybody else. Only exemption is to government research organizations. So the rest of your questions don't really matter, because you'll be going from a quota employer to another quota employer. Second question that you have is, if the end client does not apply for green card, can I apply through another employer and use that to extend my current H1B after 6 years? Yes, you can, as long as you do it in good faith that you intend to join the future employer upon approval of the green card. You may never have to join them, but you've got to have that good faith intention. Okay. And the second thing you have to remember is the employer that applies for you should also have that intention. But you can use the green card proceedings through a future employer as the basis for getting H1 extension for the current employer. Um, Next question is, came to US through company A on L1B. Towards the end of my 5-year completion, company A applied for H1B. Changed to company B applied for PERM in the 6th year of my H1, which went into audit. Since my H1B was expiring and since my PERM was in audit, I joined the offshore branch in India. Few months later, my PERM was denied. Company B filed for a second PERM in November 2013. Okay. Once I completed 1 year employment in India, I applied for L1A and got it stamped. Meanwhile, my second PERM got approved. I came to USA on L1A as a regular US employee for company B. Okay. Now the I-140 was applied and got approved. My question is, can I switch to another company based upon the approved I-140? Can I switch to company C on the H-1B extension based upon my approved I-140? Well, don't you already have new 6 year of H1? That's what it looks like. But you can use the approved I-140 for a transfer over, even if you don't have 6 years of H1 again, which is, it looks like that's your situation. You can switch from L1A to H1B, but only if you're not subject to the quota. By being outside USA for more than 1 year, you become subject to the quota. I think it's a little bit more complicated than that. Let me think about this. So you've got more than 1 year outside USA, and the only thing that will take you outside quota is if in the last 6 years you have been approved for an H1. And you were approved for an H1 last when? I don't know. So have your lawyers look into the fact whether you're quota exempt or not. But as far as going from L1 to H1 is concerned, that's not an issue at all. Okay. Dave wants to know. So he's watched all my YouTube channel and listened to all my videos. Well, that's a lot of videos, over 100 videos there. Good for you, Dave. I need your validation regarding my visa situation. I'm on H1B. My PERM was filed last year, September 2013, not approved. Max out date is September 5th. So there's a 8-day gap there. You have Canada work permit, you're going for 3 weeks, so you can push your max out date. Good. I don't have a valid USA visa, so I'm going to use AVR, automatic visa reval. I will not surrender 94. So I have the following questions. Will I be allowed to leave USA without surrendering the I-94? Absolutely. Can you re-enter on a Xerox copy of I-94? No. Will I face any issues while entering back into USA? You're not going to apply for a visa. You are staying for only 3 weeks, not going to any other country, and you're carrying printouts of the CBP regulations and federal regulations. I don't see any problem with this. I think AVR is quite obviously applicable. There are a few countries that are not allowed to take AVR. It used to be 8, I think now it's about 6 countries like Syria and all. But India, I'm assuming you're from India, should have no problem. It looks like a simple case for AVR for me. Can H1B extension file from outside USA? You should be in the US when you file the extension. But once you file the extension, then you can travel and the AVR can be used. Can the extension be applied in the beginning of the month? Yes, yes. This is an interesting situation. See, let's look at the figures. September, right? So September means you can even apply now. You are eligible in September 2014, right? Let's see. Yeah, yeah. Your H1B max out is September 5th, 2014. And on September 20th, 2014, you become eligible. You can apply now. You can apply now with September 20th, 2015 to September 19th, 2016 as the dates of your H1. Okay. So that's not a problem. So you can apply for the H1 extension now. Because the date from which your extension kicks in, which is September 20th, is more than 1 year since your perm has been pending, which is filed in first week of September. Okay, so yeah, I don't see any problem with the H1B extension filing now. Neil134 says, I'm on H1B. I did a change of status from F1 to H1B. Fiance is a German citizen who will be on tour in US soon. Well, look, trying to convert status from tourist, even if it is, well, first of all, if you are on a visa waiver, you cannot change status. But if you're on a regular tourist visa, even then, if you try to change status, government can call your entry to be a fraud. Okay, so I think it's a very bad idea to do a change of status. Okay, I think the rest of your questions are automatically covered underneath that, but change of status within USA is a bad idea. I am also a little hesitant to say that getting married being the purpose of travel is a good idea. I think it'll be better if you go to Germany and get married there. Okay. So Victor underscore 25 says, I-130 application for my parents of a US citizen. He understands that it's not recommended to apply for green card immediately after they enter. How long should I wait? Look, the law is they should not have a preconceived intention to convert to green card at the time when they apply, when they enter USA. So if they have already decided they're going to apply for a green card and they brought their birth certificate and marriage certificate, things like that with them, government can take the position that entry was fraudulent, even if you apply 5 months down the line after the entry. So first requirement, no preconceived intention. Second requirement, if they apply within the first 30 to 60 days, it's problematic by itself. So they should not have a preconceived intention, then wait at least 60, 65, 70, 80 days after they enter. It can take a little bit less time if you apply for 485, but there are consular processing of green cards in certain consulates where it could be even less time, but you know that you have to check with the consulate where they live, whether the consulate can process the I-130 within the consulate. If they apply for a green card from their home country, can they travel to USA on their current visitor visa? The answer is no. Well, let me rephrase that. The answer is they can be stopped from traveling. They can be stopped from entering if they have a green card pending. Okay. Samir wants to know, I'm an Indian citizen married to a US permanent resident. Now, what are the predictions for the F2A category? I do not know. I don't think I can answer that question. If she becomes a US citizen, what is the fastest way I could get a visa or travel permit? You would still have to go through the green card process. What you should do is, if she becomes a US citizen, see if you can apply for a K3 and an upgrade to the spouse of a US citizen on the pending case. Okay. Is direct consular processing or consular filing an option? Well, let me explain to you what DCF is. DCF is simply the process where the consulate adjudicates the entire case without involving USCIS in it. This is a local process. I'm not even sure if it's available anymore. We haven't done one in a long, long time. Check with the consulate. If you're an Indian citizen, I don't think you will get DCF. DCF is not available because in New Delhi, USCIS has its own office. So you can check. I don't think DCF will work for you. And really what you need to do is send the US consulate in India an email. They should be able to explain it to you. Then MJA Hire. PD is June 2008. 485 is initial review. And you got a very strange email. We mailed you notice that we certified our approval of this case and sent it to appropriate appellate body. There's some mistake. This email is too mysterious. It doesn't make any sense to me. There is no appeal of a 485. So I don't know what they are talking about. Please contact the US customer service and figure out what is going on. This email could be a mistake and should be a mistake. Here is my education history. This is Crazy Ben. 3-year bachelor's degree, 2 years MBA India, 2 years master's technology management USA. I'm assuming your technology management degree is from an accredited school. If it is not, it's not worth anything for green card purposes. Your job requires 5 years experience with bachelor's or master's with 1 to 3. See, the problem is masters with 1 to 3 may not go through the US Department of Labor. This formula is not correct. So please double check with your lawyers. This will not qualify, or if Department of Labor spots it, they will deny this case. Okay, it can be done, but it's got to be done differently. Talk to your lawyers, see what they come up with. If you end up being employed by end client and you are already working for them, you still cannot use the experience you gained while working at the end client site. It has to be a sufficiently dissimilar job. So are the wages of 90,000 sufficient? I do not know. Wages depend upon the job category. EB2 ends up usually being level 4 for most IT jobs, and it also depends upon the job location. So me forever wants to know marriage certificate and birth certificate for my parents for I-130. They don't have a marriage certificate and birth certificate. Well, you have to have some evidence that you tried getting that. So for marriage certificate, if this marriage was never registered, you'll provide 2 affidavits from people that say that they attended the marriage, and then an affidavit from your parents that the marriage was never registered. So it's going to be a little complicated. Maybe you can handle it, maybe you can't. I would say get yourself a lawyer if you have doubts. It can be handled, but it'll need an affidavit both about the non-availability of the marriage as well as the validity of the marriage. Okay. For the birth certificate, again, you must have tried getting a birth certificate from the municipal corporation where they were born. If the birth was never registered, the municipal corporation should be able to give you a certificate of non-availability. And for birth, you can also do this. You can offer the government that you'll be okay to do DNA processing. So DNA testing can be done to prove birth. Both your parents' birth can be their parentage can be established through DNA testing. John Bosco wants to know about DV lottery. I'm sorry, I don't know anything about DV lottery. 2 things I don't do at all: DV and political asylums. Okay. Then Mohit, New Jersey, Mohit NJ is on H1, wife is on OPT, filed 485, advanced parole. It's pending. Can I travel on H1 while AP is pending? Look, ideally avoid travel until the AP is approved. But if you have a visa stamp already and you travel after applying for an AP, I think it's okay. Double check with CBP. Your travel should not be a problem, but your wife's travel can be a problem. I don't think she should travel. She should wait until she gets her AP because she's on F1. It's very tricky. When you're on F1, you're not supposed to have a 485 concurrently pending. They're not going to create a big problem about it, but if she travels, she would have a problem. So if you travel on your H1 visa, then AP gets approved, can you get it sent to India? People do it. People do it. I'm not sure how legal it is, but I think you can use it. But if you have a visa stamp, you can enter on H1 visa stamp. If you don't have an H1 visa stamp, wait until you get the AP approval. How much time can you stay outside? As long as your job is available, you can stay outside all the way till the time the AP is about to expire. Okay? Then Houston Krishna, I-140 approved status, vendor wants to hire. Okay. You'll have to start labor again and then port the priority date. That's correct. Is there a way to avoid this? Well, there is if the old employer keeps the job open. But the problem is the old employer can keep the green card going. I always have trouble with these cases because if you really wanted to join them at a future time, which is the basis of the green card, why did you skip it? Why did you change employers? Okay. So it is possible theoretically, and USCIS has not created too many problems for people in this situation. But I'm always leery of this, and I want you to be prepared to answer that question, that if you wanted to join this employer on a permanent basis, and they have a permanent job for you, how come they are okay with you going over to another employer in the interim? Okay, you're a asylee. I'm sorry, right way. I must tell you, my apologies. I don't know anything about political asylums. You have a fraud and misrepresentation case, Melly Sotanto, and here's the problem. Fraud is not a 5-year bar. Fraud is a permanent bar from entering USA. Okay. I don't know if it was the same law in 2007. I think it was. It is kind of complicated. It's not something I can tell you off the top of my head. But if there was indeed fraud and misrepresentation in your background, the 212A6C now is a permanent bar. Okay. Is it possible to reopen the case? Yeah, our firm handles cases like this. You can send me an email to help@immigration.com, and I'll have somebody contact you and set up a consultation for you. But these are not easy cases, and we do deal with these kind of cases all the time. Okay, but don't think it's going to be easy. Next question, Krish, Forum Houston, parents' green card and path to citizenship. Is it okay for them to stay here 10 months in a year and 2 months in India? Absolutely. If it is just a brief visit, they get their green card, and it doesn't affect their citizenship either. Citizenship starts getting affected if the visit is more than 6 months in any 1 year. Okay. So very quickly, the requirements for citizenship are, number 1, you must have had a green card for 5 years. Number 2, you must have been physically present in the US for 2.5 years, 30 months. Number 3, none of your stays outside USA should have been 1 year or more. Number 4, if your stays are more than 6 months, less than 1 year, they must be explained. If they are less than 6 months in any 12-month period, not a problem. Okay? I don't know anything about eligibility for Medicare or Obamacare. That's something you'll have to discuss with somebody else. Britt Simon, you are a volunteer moderator. Simon, I don't know the answer to your question. And by the way, for our volunteer moderators, you just send me an email when you have an issue. The least we can give you is give you some free legal advice. So send me an email. You have my email address. I'll have this looked at and I'll get back with you about what the relationship of stepmother is and how it can affect filing for a green card for her. I don't know the answer off the top of my head. Okay. Satish wants to know, applied for H-1B for my wife this year, got it approved. She's in H-4. If she wants to travel, is she allowed to travel and come back on H-4 visa? Definitely. If the H-1B is approved, she'll have 2 choices. Apply for a change of status back to H-1, which is like filing the H-1 all over again, or go get her visa stamping. Okay. Prasad 121, I'm on H1B. I'm planning to open a company. Well, is it legal to open a company? I've covered this issue many, many times. I'll do it one more time. The essence of this problem is if you're on H1B, unless you are approved for a true employer-employee relationship where somebody can fire you from the company, you cannot do an H1B for your own company. Without an H1B for your own company, you cannot really do any work for your company. And work would probably include things, even things, simple things like hiring a person. Okay. So, can a person in India manage a US company? The answer is yes, they can. More tricky question is, can you on H1B be involved in this company in any way? I don't think you can. Okay. So, the limit of H1B is that you can do passive investments. It's like putting money in the stock market. So if you put $100,000 in IBM stock, it does not give you the right to manage IBM or to start signing papers for IBM. So passive investments without any control are okay on H1B. I'm currently on Cap Gap. This is from ASB underscore NC. Got my H1B approved for employer A. So can I transfer to employer B even before October 1st? Yes, as long as this is something we discussed with USCIS recently. And they said, as long as your application for transfer is received before the old employer revokes the H1, they will consider you for transfer. So even without working for employer A. But double check that with USCIS, they are not known for their consistency. Payal Sen is a postdoc on her second postdoc job here. Fourth year of H1B with her second employer. Received H1B in September 2010. Stamping from India done. Not done stamping for the second H1. Do I need stamping for home country? Or can I do interview waiver? I don't know. It depends upon which consulate you are going to for. So check the local rules. If the local rules definitions allow you to file for waiver or interview waiver, definitely. Look, you don't need a stamping for extension. You only need visa stamping if you don't have an I-94 or if you're traveling outside US. You also don't need visa stamping to apply for a green card. Okay. So as long as you have a valid I-94 covering your employment, you only need visa stamping of the H1 if you are traveling outside USA. Mahesh MK Vish says, I'm a returning user to the forum. He's a US citizen. Parents are visiting, debating about applying for their green card. I've discussed this issue before, just a few minutes ago. But yeah, if they are here and they enter without any intention of changing to green card, and a few months later they decide to, and then they want to get parole and travel, or even stay outside USA during the life of the parole, or come and leave as many times as they want while the parole is there, no problem at all. Marriage certificate, etc. I also discussed this issue just a minute ago. Just listen to the discussion. And if you're on the phone, we can talk about it. I had just applied, got green card for my wife 6 months ago. Does that matter? It should not, as long as you make enough money to support everyone. And the threshold is not very high, maybe $30,000, $40,000, $50,000 a year. That's all you need to sponsor 3 people. So I think you should be okay from that angle. All right, I'm done with answering the questions that people had posted. No new questions right now. Any follow-up questions on what we have discussed so far? Follow-up questions, press *5 on your phone. *5. Follow-up questions only, no new questions. One question, one person. Press *5 on your phone. 2, 2 questions. Star 5, press star 5 if you have follow-up questions. Okay, we might have enough time to do new questions also. So let's go in the order people called in. So you are a Google Voice caller from area code 760. Go ahead, please.
Hi, I'm HDNC.
Do you know the number of your question?
30, number 30.
I have you in front of me. Gap, H1B approved, transferring without joining the employer who sponsored the H1. Yes, go ahead, please. What is your question?
Yeah, so I just wanted to confirm that I don't need any pay stubs or anything, right? And this transfer can be done even today or tomorrow, and I don't need it to be near October 1st.
Yeah, we double checked that with USCIS just last week. And USCIS said that's the way it is. As long as your transfer application is received before the old employer revokes your H1, they consider you to be quota exempt. But because this is such an important issue, I want you to double check or have your lawyers double check with USCIS that their interpretation of the law is the same this week. Every week they change their mind.
Okay. And the situation is that I had actually applied for my H1B in my 60-day grace period.
Okay.
So I only got my F1 status extended, but I am not working currently with my employer. I used to work with them till first. That's when my STEM extension got over. So will that also? This I'm just here on status. I'm not. I don't have an EAD, and from 1st October, I can legally work for employer A, but I want to switch to employer B. So does that change anything?
Well, let's see. Um, I don't know. That's a very interesting question. See, normally, um, gap will take you all the way to October 1st. You are in the 60
Yeah.
day after the F1, right? After the OPT?
Sorry. Can you repeat that?
You are in the 60 day after the OPT?
I was. My STEM extension got over on 1st March, and 1st April they applied for my H1B.
Yeah, then you cannot work, right? So you have not been working, and of course you
Yeah.
cannot work. Um, but are
Yes.
you? But you're not okay to stay once the H1 is approved. So I think you're going to have to go for a visa stamp.
Okay. So if I do switch it, I might have to go back and get a stamping and come.
It looks quite certain to me. I've analyzed the situation very quickly, but it looks quite obvious to me that you're going to have to go for visa stamp.
Okay, but I already got the new I-94 with the approved H1, so
Yeah,
that
but
doesn't
that
matter.
kicks in on October 1st. I don't think it changes anything.
Okay.
All right.
Yeah.
Good luck.
Yeah. Thank you.
You're welcome. Okay. We've got 2 more follow-ups. Let's go with Connecticut. Connecticut, go ahead, please.
Uh, Rajesh, hi, this is Mahesh. My number is 32.
32. Haji Mahesh, go ahead, please.
Yes, sir. Just wanted to ask the reason my parents want to process their GC is because of my medical condition. They would like to stay with me. I'm going through depression, fatigue, that kind of thing. I have a doctor's thing to go with that, I guess. Does that change anything? And number two, is it better one way or the other if they file it while they are here or if they file it after they go back to India?
There are too many things that can be considered, Maheshji. But let me get a couple of things straight. When did they enter US, Maheshji?
They entered, it's been 3 months now.
You should apply for them while they are still here. They are going to get their advance
Okay.
parole. You apply for their advance parole. That way, in 90 days, they've got advance parole. If they want to travel in and out, they are free to do so over the next year to 2 years. Yeah, applying for them makes the best sense.
Apply for them while they're here. Okay.
Yes, sir.
Okay. Great.
All right.
And yes, sir. Great. Thank you. And is it okay for them to work or apply for employment authorization, or is
Why
it not a
not?
good idea to do that?
Why not? Of course. Let them get employment authorization. And the employment authorization advance parole comes on the same card now.
Okay.
All right?
Okay.
Yeah, apply for it.
Great. Yes, sir. Thank you.
You're welcome.
Great. Thank you.
Good luck, Mahiji.
Sorry. Thank you, sir.
Okay. Let's do the last follow-up question, then we'll start with the new questions. This is Wisconsin. Wisconsin, go ahead, please.
Hello. Can you hear me?
I can hear you fine.
Okay. Basically, I didn't post any of the questions, but I have a follow-up question on someone else's question.
That's
Is
okay.
that okay?
I can take that. Go ahead, please.
Okay. Yeah. So question number 2, which is essentially the question number 1 by page 1 to 3.
Give me 1 second.
I have a follow-up question on that.
Give me 1 second. Let me get to that, okay? Bear
The
with me.
very first question, I guess.
I got it. 1 second. So the question is, I'm on H1, I-140 is approved, received H1 extension for 3 years. Can I switch jobs? And if they revoke my green card application, what are the options? Yeah, got it. Go ahead, please.
Okay. Okay. So my question is, so in this case, let's say I have an employer A who has filed my 140, which is approved, and I'm currently on my H1 extension past my 6-year period based on the I-140 approval, right?
Got
Same
it.
situation.
Exactly the same situation. Yeah.
Right. So now if I'm thinking about switching jobs, then question number 1, let's say the job has the same function or everything, the new employer would still have to start with perm and labor and everything.
Let me stop you for a moment. There are 2 concepts. One is an AC-21 transfer. That's available only when your 485 has been pending 180 days after the I-140 approval. Or the I-140 is approved, 485 pending 180 days. That's not what you're looking at. You just want the priority date transfer. For the priority date transfer, the jobs can be completely different. It's not a problem.
Okay. And let's say if the job is completely different, maybe a different function, different area, the priority date is still for you to keep?
It is. Yesterday I did a consultation for somebody who was a chemical engineer and then became an IT professional. So he got his I-140 approved as a chemical engineer. The question was, he had not started his green card for 3 years. His lawyer told him that he couldn't do, I think his lawyer told me that he couldn't do a priority date transfer because he had changed fields. And in my opinion, that was absolutely incorrect. You can change professions also and still carry the same priority date.
Okay. Then my next question is, so in this case, obviously, since I'm currently on my H1, the new employer will have to file for the H1 transfer, right? So, let's say if the transfer is still being processed. Hello?
I'm listening. I can hear you.
Yeah. So let's say if the transfer is still being processed. Now, this transfer is for an H1 that was awarded based on the 140 approval. So let's say if the transfer is still being processed, I haven't heard the decision, and let's say the employer A revokes the I-140. Then what happens?
I don't think you will
Does
get.
it mean that?
I don't think you'll get the extension. So
Okay.
I think it's important that the revocation occur after you get the extension.
Okay. So the revocation cannot occur before the decision, right?
That is my best guess.
Okay. And then let's say if the revocation occurs, like H1 transfer, you have the new approval, and then the I-140 with employer A is revoked, and employer B, the new employer, hasn't yet filed any firm or I-140 or anything. Does that mean that this H1 transfer, does it mean that you lose your H1 too, or?
No, they don't go after an approval that they've already given. So once the extension is approved, and let's say you haven't yet even joined the new employer, they're not going to, and the old employer revoked the I-140, they're not going to take away the extension that they've already given you or transfer that they've already given you.
Okay, so that.
Yeah,
so that
I
is
have
still
to
valid,
look. I'm sorry.
even though the 140
Yeah,
is already
I have to
valid.
interrupt you. Hang on. I've spent a little bit more time than I had anticipated. If you have a very quick question that I can answer in 3 seconds, go ahead and ask, because I want to ask if there's any other people with new questions.
Okay. Okay.
But stay on the phone. Think this through. If you have follow-up questions, just raise your hand again. Let me put you in the queue with the rest of the people. Guys, anybody has any question, please press *3. Any question at all, press *3. Okay, I don't think we have any new questions. Why don't you go ahead, the gentleman who was on the phone with me just a second ago, you can press *5 again if you have any follow-up questions. Anybody, any new questions, any follow-up questions? 2 people. Okay, 2 people. Let's go with California first. California, go ahead, please.
Hi, Raji.
Yes.
So I have a question regarding my perm petition that has been filed by my employer. And in the job opportunity information part of the application, they have mentioned educational credential as MBA in marketing or strategy. And I have an MBA from Yale, but my transcript or degree does not specify a major, although I have taken courses in strategy as well as in marketing. So how do I address this problem?
Oh, easy way to do that is you can get a letter from school that says that you in fact have a focus on these 2 areas.
If the school is not willing to provide such a letter that I had a focus in strategy or marketing,
Oh, that's
are there some?
there's nothing. Well, then you can try getting it from a credential evaluation service, but that's not very good planning, in my opinion, on your lawyer's parts not to be prepared for that. So, but it has happened. That's where we are. Things can happen even in the best planned cases. So, in my opinion, those are the only 2 methods. Of course, letter from school being the better one. Second method is a evaluation, and third is just to argue based upon the transcript.
Getting a letter from the school in any form is the best way of addressing this. If not, get an educational credential evaluation.
Correct. And if not that, then just argue your transcript. Look how many courses I've taken.
Sorry, I could not hear the last thing that you said.
Argue your transcript that I've taken so many graduate level courses in these areas.
Oh, okay. All right. I have one more question about the designation that has been mentioned in the perm petition. It is a marketing specialist designation.
Okay.
And the offered salary is less than what I currently make. So I make about 105,000, but the offered salary is 70,000 in the competition. Is there a valid concern about that?
That is
offered salary is less?
that is a big problem, in my opinion. If the government wants to make an issue of it, they can make a very difficult issue out of it. Why would your employer file an application for 30,000 when you're making 100,000? Well, not an easy situation. I am going to have to. You want to set up a call with us? I will review your case. But really, the people you want to take this to is your own lawyers who prepared the case and planned the case. Ask them why this was filed that way. Maybe there's a logic here that we don't understand.
Okay, so I should get the whole petition reviewed by you.
Oh, I'm not saying you should get that done. If you are uncomfortable or unconvinced by your current lawyers, certainly we can take a look at your case. It's going to be at least an hour and a half long process. We have to review all the paperwork, then talk with you, maybe even talk to the employer, try to understand what happened. Or you can go ahead and file, there's not much we can do to change this. You can file the the I-140 and see if there is an issue about it. If they do raise an issue about it, you can do a consultation at that point of time. So those are the two choices you've got. Okay?
Okay, so either I wait until the I-140 is filed, or I kind of get it reviewed at this point of time to understand possible issues.
That is correct.
Okay.
All right.
All right.
Well, good luck to you, sir. Yeah.
Okay. Fine. Thank you.
Did you have a follow-up question that I can address in a second or two? Oh, yeah.
I don't know. It seems there is nobody else on the line.
No, there's two other people who are waiting.
Oh, okay. Okay.
All
All
right.
right.
Good luck.
So,
Yeah.
I'll set up a call with you sometime, Rajiv, to discuss this.
No problem at all. No, you can send me an email to help@immigration.com.
Okay.
All right.
Thank you.
You're welcome.
Thank you.
Good luck. All right. Bye. Okay. Let's go to Arlington, Texas. Arlington, Texas. Go ahead, please.
Yeah, hi, Rajiv. Good afternoon.
Good afternoon, sir.
Yeah, my name is Karthik. Actually, I have a question regarding H-1B extension petition. When I was at a client site, a different client site, client number one, my petition, H-1B extension petition, my I-140 is approved. It was processed in regular processing. Then, after the project is over, I moved to client two. In a different state, it's a different project, but within the same company, it's a different project. So when I moved to a different place, then I upgraded the petition to premium processing. So immediately after a couple of days later, I got an RFC on the petition, on the H-1B extension petition. Could you please advise like what I need to do at this point of time?
Let me try to understand. First of all, you were working at a client site for a client X. An H1 extension was pending. Is that correct so far?
Yes, that's correct.
Okay. While the extension was pending, you changed over to client Y, correct?
Correct.
Okay. Now, did your H1 already expire? The duration of your H1 already expire when you applied for transfer from X to Y?
Well, actually, when I was at client X, when my employer filed my petition, my I-140 is approved.
Okay.
And my H-1B extension at that time, I still have validity like a month or so, something like May 2014, and my employer filed it in April 2014. Based on my I-140 approval, they applied for like.
Hang on. You haven't answered my question. My question. No, listen to me. That's all right. Listen to me. My question is, there is client X and there is client Y. When you applied for transfer to client Y, did you still have H-1B, valid H-1B, or had it expired?
It's expired.
Okay. Now that means your status is based upon approval of company X's extension.
Oh no, actually, I'm sorry. Actually, I moved to client just like 1 week before. Just 1 week before, I moved to client Y. Yeah. I'm sorry. Just like it actually it expired May 30, 2014, and I moved like on 24th or 25th. But I got my LCA from my company like on June 2nd or June 3rd. So.
No, you're confusing me with the dates. Just answer my questions as I ask them. Just focus on my question and please answer them without giving me the exact dates. Do your own calculation of the dates. Just answer my question. On the date you applied for transfer to end client Y, was your current H1 still valid?
Yes, it is valid, but it is not employer X to employer Y. It is the same employer but different process, different client.
Same employer. Well, I understand the same employer. I'm not
Okay,
talking.
I'm working for a company, and I was working at client X when they applied for my H1B extension petition with the same employer, and but my project was over at client X, so I moved to a different client Y in a different state, but the same employer.
Okay. When they applied for extension with client X, the project for client X was already over. But you filed for employer Y. Now, this is the important part, and you're not answering my question. You're going round and round in circles. I'm asking you only one simple question. The date USCIS received your H1 transfer to employer Y, was your petition H1 approval for end client X still valid?
Yes, it was H1B petition was still valid.
Okay, this is the important part, because if it was still valid, even if the access case gets denied, I don't care, because when you filed for the transfer to employer Y on that day.
No, there is no employer Y. There is no employer Y.
What I mean is end client Y.
No
I mean end client Y. I understand. End client Y. It's the same employer, different clients. I understand that. So excuse me for misstating. You are
no problem.
Okay. So your client Y, when the transfer was filed, your H1 with client X was still valid. That's all I care about. If it was, I don't care if that extension gets denied.
In other words, could you please? I mean, I'm sorry. Could you please clarify one more time, if you don't mind, Mr. Rajesh?
I can try. Here's how it is. If I'm working, let's say my employer is, let's call him employer. Okay, my employer is employer, and I have two clients, client X and client Y. I'm working for client X, but it looks like I'm going to have to transfer out to client Y. So what we do is we file for your transfer to client Y through your employer, and we file it while your approval for client X is still valid. So let's say their approval is expiring on July 30th, and USCIS received your application for transfer to client Y on July 29th. Are you with me so far?
Yes.
Okay. At the same time, before I filed the transfer, on June 1st, I had also applied for an extension of your H1 with client X. Are you with me so far?
Yes.
Now, even if the extension request for client X is denied, it should not affect my transfer request to client Y, because on the date July 29th, on which USCIS received my transfer request from X to Y, my petition for X was still valid till July 30th. In that situation,
but Rajiv, I'm not sure why you are specifying transfer, because there is no transfer. It is just an extension. I'm sorry. There is no transfer from. It is just it's just a site location, client site location. Project is different.
All right.
No transfer, it's just an extension.
Actually, you are correct again. If we were to be very technical about it, the exact petition, it will be called H1B amendment with an extension request. Okay, it doesn't matter what you call it. Let's call it change of end clients. So if the change of end client request is received by USCIS while your H1 is still valid, then an extension request with the earlier end client does not matter whether it gets approved or denied. Okay, I gotta take the next call. I think I made myself clear, right?
Okay.
Okay, so I really, let me just get the last call first. Stay on the phone. If I still have time, I will spend another couple of minutes with you. Okay, give me 1 second.
Okay, thank you.
Yeah, Wisconsin, go ahead, please. Wisconsin.
Hello. I actually was talking to you earlier and you kept me on hold. This was regarding question number 1, the very first question.
Okay.
And I just have one final follow-up question.
Oh, give me 1 second. Let me refresh my memory. I kind of lost it. Oh yeah, switching jobs. I-140 approved. Yeah, go ahead, please.
Right. So if I understand right, if I'm switching jobs from employer A to B and the H1B transfer when my 140 is approved, it is not okay if the 140 is revoked by employer A while the H1B transfer is still in process. But it is okay once the transfer is already approved, even if the I-140 with previous employer is revoked, right?
That is correct.
So your H1B, once it is approved, the transfer, that doesn't get revoked because the 140 is revoked.
That is correct.
Okay, I just wanted to confirm that. Thank you, sir. Thank you
Oh,
so
you're
much for your
welcome.
time.
Oh, you're welcome. Good luck.
Have a good day.
Bye-bye. Karthik, go ahead. You are the only one left now. Go ahead. Tell me, what have you not understood?
Thank you.
What have you not understood about this?
Okay, so this is the, sorry if I confused you, Mr. Rajiv. My case is like, my situation is very simple. It was May 30, 2014 was H1B extension was expiring. I-140 is approved. My employer applied in April 2015 just with a project with client X.
Okay.
Then after a couple of months later, the project was over, but still that that requirement like a statement of work or something like that with the contract with my company is still valid till October 2014. So anyway, I moved to a different client X in a different state, but with the same company. No change in employer, same company.
Hang on 1 second. Your project was over when?
Yeah, it was over like May 24th.
Okay, let me make it real simple for you. I think there could be a problem with your status. I think government could take the position that you are out of status. We will approve the amendment and move over to employer Y, but you'll have to go outside USA for visa stamping. I think that's where you're headed.
There is no, sir. There is no employer Y. There is only
client Y. I got it, man. I got it. Just stop. Listen to what I'm saying. I understand the situation. I keep saying employer. That's my fault. It's the client Y. What is going to happen to you?
Okay, no problem.
My guess is, and from what I can tell, it looks like you were out of status when you applied for an amendment transfer over to client Y. Therefore, chances are, there are some situations, I can't spend 45 minutes analyzing your situation. I can answer brief questions, a couple of minutes here and there, but this really requires a lot of analysis. Bottom line is this: if you were not in valid H1 status on the date USCIS received a request for amendment of the H1 to take you over to client Y, then even if they approve the H1, which they probably should, they will ask you to go outside for visa stamp.
Okay.
That's about
but I don't understand why USCIS will consider out of status when my petition is in processing. It's just a request for evidence or additional evidence or clarification.
There are actually a couple of problems here. It appears to me, and I just looking at what you're saying and knowing how some employers might be doing it, USCIS can come after the employer for a fraudulent extension request also. By the way, an extension request by itself does not give you status. Until it is approved, it does not give you anything.
Okay. So, but earlier you were saying that, if I understood correctly, you were saying that even though the client X petition gets denied, but still, because you already moved to client Y.
No, stop. That only works if the amendment request was received by USCIS while you were still in H1 valid status.
I see what you mean.
If you are 1 day over it, you will not be approved.
Okay.
Because
So
it's
in
like
this situation, let's say,
it's like a series. The moment you go out of status, complete status, and you are relying upon a pending application to give you status, unless that pending application is either approved or clearly approvable, they will not use that to bridge the gap between statuses from X to Y. That's the problem. It's a complicated issue. Talk to your lawyers. I'm done talking to you. Bottom line is, unless you are in complete,
I understand, Rajesh. Thank you so much.
when you are unless you are in complete status, you cannot rely upon extension to give you status until and unless that extension is actually approved or clearly approvable. I am concerned if the employer applied for an extension without a project, they can come after the employer for fraudulent extension. Okay? I've seen that happen.
Okay, but at this point of time, okay, one quick question, Rajesh. I will not ask anymore. So at this point of time, let's say because right now my company is preparing for that RFP response and things like that, they ask for additional documentation from me. Because the new manager is there, a new manager letter, signature, new client, everything. All the time while they are doing it, if I find a new employer, it's a new employer while this RFP is pending. Can I successfully, without any issues, be able to get the extension based on my I-140?
You'll have to still go outside US. Let me tell you why.
Okay.
It's very simple. Currently, you are not in pre-existing approved H1 status. Even though your H1 is valid, let's say till 2016, you are not working for the approved end client.
Okay.
Therefore, unless you can only go to employer Z successfully without having to leave USA if both X and Y are approved or clearly approvable. It's like a daisy chain.
Okay.
That's why. Okay. I'm sorry, this is all the time I have. Good luck to you.
Actually, this is like a full consultation you gave me.
No, I'm not worried about the consultation part. That's my pleasure. I'm glad you are here. I could give you some direction. But some issues are so involved and complicated. Your lawyers can best answer them in the context of your own dates. So I can give you the general statement of the law, but ultimately how that applies to your case, how did they file the case, that all they can answer best. Okay?
Yeah, actually, at this point of time, I'm not really worried about the status anymore. I'm so disappointed because I've been here for 15 years without the green card. And I've been like transferring H1, F1, H1. I'm really done with this US. I can go back to my country happily. I really don't care about this.
Oh, no, I believe you. But, if you have built a life here, when you go back to your country, it's like being back in a foreign land. Of course, it's disgusting how badly the immigration system is set up. But I think what you should do is wait, watch how it develops, make sure that, at least try for the visa stamping if there's a problem. If that doesn't work, of course, there's always that chance of, always that option of just staying back and, finding work locally. So it's okay. All right.
Okay, thank you, sir. Have a good day.
You too. Bye-bye. Good luck, guys. Thank you, everyone.
Bye-bye.
I will see you Thursday after the next one. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time every other Thursday. We have free apps for both Apple iOS platform for your
iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.